Call the final case of the day, 125865, State of Kansas versus Jason Cunningham.
May it please the court, Jason Cunningham appears through counsel Jacob Noah, the appellate defender office. Chief Justice, may I please reserve 3 minutes of my time for rebuttal?
3 minutes is granted.
Thank you. As I drafted the petition in this case, my largest gripe with the Court of Appeals decision was one of a perceived logical inconsistency, and that they were applying a rationale to sexual works of art that I was more than reasonably confident they would not apply to other unpopular works of art. And to that end, I drew upon my own personal experience as a horror movie fan. I enjoy horror movies, particularly slashers like Friday the 13th and Scream. And those movies, at their core, what they do is they depict and glorify violent acts. And yet I'm positive that despite this disclosure, no one in this courtroom thinks that I now have a propensity or proclivity to go out and engage in violent acts on my free time. And so it doesn't make sense that we would apply that same rationale to sexual works of art, specifically pornography in this case. And as I began to thought about this issue more, I realized that what the Court of Appeals did isn't necessarily novel. It might be new to Kansas appellate case law, but society in general tends to criticize or demonize new art as it is released. To that end, I think it makes sense because the bulk of art is produced by and for younger generations. There's an old observation at this point that if you ask someone what their favorite musical artist is, they were more likely than not say somebody who was popular in their 20s, because that's an age where people's artistic consumption is at its height. That's an age when tastes are still being developed. And at a certain point, everyone's artistic tastes do kind of get set. Not that they're completely finite, but a little more rigid. And so we've seen this historical pattern of art being criticized as it comes to fruition. A couple of the ones I lived through is, in my younger days, they told us that video games, particularly violent video games, such as Mortal Kombat or Grand Theft Auto, were going to turn us into deviants who had a propensity to commit violence. They said similar things about Harry Potter, of all things, that it was going to turn us into devil worshippers, which they also said about, before my time, Dungeons and Dragons. And throughout history, we've kind of said similar things about different genres of music as they've come, that they were going to rot the youth's brains, be it rock and roll, hip hop, rap, heavy metal, or what have you. And the thing about that historical pattern is, after a few years, we always seem to decide near unanimously that those fears were unfounded, that those claims were not credible. And so I'm hoping as we get into this discussion today that we can realize that since we've all applied that logic to the art that came out during our generations, that we can also apply that benefit to the art that is being produced by and for younger generations. And to an extent, that's what this court recognized in its opinions in Smith and Boland. Now, admittedly, it didn't wax poetic about the pursuit of art in the face of adversity, but it recognized that key component that watching pornography, whether it be homosexual pornography, heterosexual pornography, it has no relevance on whether or not the person consuming that pornography will engage or even have a desire to engage in the behaviors depicted therein. And for a while, that was just how the rules were applied. I did trial work, and I've never had this come up where a prosecutor was asking to get pornography admitted, probably because we had those cases. Recently, we had a decision in State v. Sheets, which, as I interpreted it, created a narrow exception to those cases, because the state did ask this court to overrule Smith and Boland when it was up here in State v. Sheets. And it also asked this court to carve out an exception from State Boland for incest-themed pornography. The court didn't do either of those things. Instead, what it did, and it's important to note that Mr. Sheets was charged with multiple counts, including 2 counts of aggravated sodomy, 2 counts of rape, and 1 count of sexual exploitation of a child. It determined that that evidence was relevant not towards the rape and not towards the aggravated sodomy, because that holding would conflict with Smith and Boland. It found it relevant only as it applied to the count of sexual exploitation of a child, which is a crime that prescribes a particular possession of a particular type of pornography and not a real life sex act. And so when you synthesize these cases, which I think anyone analyzing the relevance of pornography in today's age needs to do, you can kind of see it. Pornography is irrelevant as opposed to a real life sex act, but it is relevant to determining what type of pornography the defendant may or may not be interested in watching. Back to my horror movie analogy, again, it doesn't make sense to say that someone who likes Friday the 13th would engage in violent behaviors, but it does make logical sense to suggest they might also enjoy Scream because that is a relevant interest to the art that they're watching. What art you look at can tell us maybe something about what other type of art you might be interested in. And so I'm asking this court to essentially recognize that, because what the Court of Appeals did was it refused to read sheets that way. It read it as broad and controlling on this issue as if there is ever an element of sexual gratification, an intent to have sexual gratification or arousal, then someone's pornographic possession or consumption would be relevant towards establishing that element. But you can't.
Where do you pull that out of what the Court of Appeals did? Because, you know, I marked on page 6 of the Cunningham decision where the Court of Appeals said that, you know, Sheets held evidence of prior sexual misconduct, and then quoting, may be relevant to a person's sexual desires when those desires are material facts necessary to prove an element of a charged crime. And then the Court of Appeals goes through and looks at each one of the counts and associates materiality to that. I don't see some kind of an automatic, you know, if you've got dirty pictures, it automatically comes in. I see the Court of Appeals as saying that, you know, it may be relevant if it ties back to these elements.
Right.
So where is the language in the Cunningham decision that says this is an automatic admission of evidence? I don't see that.
Well, they're saying it's automatically relevant, I suppose. There's obviously questions beyond that.
What does the panel say that causes you to find that interpretation? That's all I'm asking. I know I got the decision right in front of me. Where do I look here to see what you're saying the panel did?
Right.
Because the parts I've quoted tell me they didn't do that.
Well, it's the parts you quoted that then lead into them going into the statutory elements and emphasizing the intent for sexual arousal and sexual gratification. That's where they're saying that is the disputed element that is at play in this, that this becomes material to. And the problem with that is that those elements were at issue in Smith and Boleyn. Those two defendants were charged with aggravated indecent liberties with a child. So the issue of whether or not they acted with an intent to obtain sexual arousal or sexual gratification was at issue. The problem with the pornography, is that it's not that those things aren't material. It's that this court has already recognized twice now that isn't probative towards establishing that material fact. That's what we have in State v. Boleyn and State v. Smith. The court went into it in great lengths in State v. Smith, where it described how that's inconsistent with what we said in Boleyn. It is inconsistent with this scholarly article that we've cited to from the Archives of Sexual Behavior, and that if it is not going to be relevant to prove that someone might have a homosexual tendency, we're certainly not going to say it's relevant to prove that someone has a heterosexual tendency. And so if you can't assess the relevance of pornography without divorcing it from Smith and Boleyn at this point. And I'm not, I suppose, here to say that Smith and Boleyn can never be challenged from the state, either generally or more specifically on a fact-specific basis. But in order to do that, you need to do it at the district court. You need to recognize that adverse authority from the get-go, but that's not what happened here. Essentially, whether it's intentional or not, the state prevented the court and defense counsel below from doing research on this court's authority as it pertains to lawful pornography, because they came in and they said it's the same thing they did in Sheets. They came in and they said they filed a pretrial motion to admit 6455D evidence, claiming that they were going to present evidence of child pornography, which would be a whole different thing. That would just be admissible under KSA 6455D. They used that motion to secure a pretrial ruling. So we don't have the court and counsel reviewing this court's authority on the inadmissibility of lawful pornography. And then at the 11th hour at trial, right before the witness shows up on the stand to testify, the state concedes and acknowledges, turns out we can't actually prove that it's child pornography. It's just ordinary pornography, but we still think it's relevant for whatever basis the jury will give those those titles. And so that is how it went in both these cases, which is why we don't get an acknowledgement of Bolin and Smith below. And to the extent that the state is ever going to differentiate those cases, it really needs to put on evidence to explain one way or the other why the district court should be differentiating those cases.
So if you take their Court of Appeals statement that Cunningham's intent to arouse or satisfy his sexual desires was an element of multiple charges against him as a justification, which you're rejecting. If that sentence said his sexual desires focused on a child, would that make a difference? Where 9, or I think it was, of the 11 were very focused on a child as the victim and or a child or a parental figure against a child of the opposite sex.
I'm not sure how it would in this case necessarily. I mean, again, all the pornographic search titles that were admitted by the state in this case, they did not prove that those were sexual exploitative materials. The presumption is that is lawful pornographic material depicting adults engaged in consensual sexual activities. So no, I don't see how that particularly would connect towards an interest in younger individuals. Now, again, if it were sexually explicit material of a child, it's absolutely relevant at that point, pursuant to KSA 6455D, but that's not what happened here. That's not what we have. This is just general lawful internet pornography, as I understand it.
Even if lawful, it wasn't the titles intended to depict something closer to unlawful? And I think this is really just a follow-up to Chief's question, that the specificity here, the titles themselves, regardless of the lawful status of the content, were at least consistently incestuous and non-consensual. Which seems to be, we're not just talking about this general category of pornography. I mean, the specificity of those titles, does that make the inferences more reasonable under these facts?
Before I answer that, Chief Justice, I see I'm out of time. I believe.
Certainly.
Thank you. No, I don't believe so. So there is, I think, a broad range here. We have some incest themed pornography. We have some rape fantasy themed pornography. We have things that have nothing to do with either of those contained in this image or this list that was presented by the state and admitted below. I don't think the specificity necessarily carries the day here for a couple of reasons. One, it's frankly not that specific to this case. We're a couple of categories of incest removed here because all of the in here is biologically themed incest, but there's also step incest pornography that's not listed in here, and there's also pseudo incest pornography that doesn't get listed in here. That would be far more specific to the fact pattern we have, because my client wasn't accused of committing incest in this case. He was accused of abusing a child, but these don't on their own indicate that it is pornography of someone abusing a child. Again, if it were, we wouldn't be having the discussion we're having today. The question is whether incest-themed pornography generally, which again, I'm going to assume that this is all people who are in their late 20s, early 30s pretending for the sake of producing art or I guess acting is a better word than pretending. That the question is whether that sort of material would be relevant to a child abuse case. And I don't see how it would be based on at least the specificity situation. And again, to the extent it might be, all we can do here on appeal is kind of take a little post hoc fallacy argument towards it, which is, well, it's fairly specific, so it must have caused the other thing. But really, without developing that record below, without putting on something from anyone to explain why that those two dots would connect, I'm not sure we can do that on appeal, particularly in light of this court's holdings in Smith and Boleyn. And with that, I will make myself available for rebuttal, but unless there are any outstanding questions, I will sit down.
Good morning. May it please the court. Tyler Winslow, Assistant Solicitor General, appearing for the state of Kansas. Firm and fair blows in a child sex case. That's what this case ultimately boils down to. And because the prosecution's presentation of KSA 6455 evidence of the bookmarks that have been discussed and in argument, because those were firm and fair blows, the state asked this court to affirm the Court of Appeals decision in this case. Stepping back to the facts for a second, I'll use the pseudonyms because I think they track nicely with the Court of Appeals opinion in this case. But broadly speaking, Jane tells a friend at school that her stepfather is raping her. A classmate overhears that, and that's when the investigation begins. The Kansas Bureau of Investigations dug in and identified not one, not two, but a total of 4 child sex victims for Mr. Cunningham. 2 of those resulted in charges, and 2 of those testified under KSA 6455. Further into the investigation is when a phone extraction yields bookmarks, which the Court of Appeals documented in its opinion, and which are now the focus for this case in terms of relevance and undue prejudice. Any tendency to prove a material fact. It's a low burden. And so any arguments that perhaps incestuous themed titles like Daddy Teaching Daughter How to Quote, Suck and Fuck, apologies for the terminology, but that's what we're dealing with here. Any tendency to prove a material fact. This is a child sex case. The relationship between Cunningham and the victim in this case is that of a I think she's referred to broadly as a stepdaughter. Ultimately, I think they were girlfriend, boyfriend. I think there was a dispute about the relationship between Cunningham and the victim's mom. But ultimately, it's any tendency. Broadly speaking, Boleyn, from the state's perspective, does not stand as an absolute bar to the admission of evidence like this. It's about what the extent to which, and what the holding is actually, is the extent to which admissibility of a pornographic preference might apply when a witness says they are open to multiple different types of physical sexual encounters. In that case, it's a bisexual individual. The pornography to be admitted, I think, via stipulation was a preference for same-sex, for gay pornography. So Boleyn does not stand as an absolute bar, is the state's position here. And ultimately, this court's already addressed as its application for this case in Sheets, how Boleyn, how Smith, and another unpublished Court of Appeals opinion all play into this type of evidence, because there's ultimately no real distinguishable fact between this case and Sheets. The state relies on Sheets for its argument. And ultimately, in Cunningham's case, the bookmarks served as corroboration to Jane's testimony, particularly given that she recalled some of the titles that she had been shown, and they're relevant to showing specific intent, which is exactly what the Court of Appeals referenced. I'll turn then to the prosecutorial error. There are two comments at issue. The Court of Appeals found neither to be error. I'll ask this court to do the same. Addressing the first comment, so if the event happened, which the state believes that it did, this is in discussing what became known as the chocolate popsicle incident at the trial court. What the prosecutor is actually doing in this case is talking the jury on to the timeline to show Jane's age when the allegation occurred, when the chocolate popsicle incident occurred, because the state had to prove her age for that charge. So it was perfectly proper for the state to make this argument, to talk the jury on to the relevant evidence, which included Jane's testimony. Secondarily, Cunningham testified, and as part of his testimony, he discussed a quote unquote mini trial that Jane's mom called him and discussed this chocolate popsicle incident. But according to Cunningham, it occurred before Jane said the allegation. The state's argument invited the jury to consider the efficacy, whether or not they could believe that argument, and ultimately argued that his own testimony actually corroborated Jane's allegations. Finally, turning to the cumulative error, and I'll address harmless error at the same time, because I think even if this court were to find error on all points, any error is harmless beyond a reasonable doubt. Notwithstanding any of the errors, if this court were to find any, Jane and Mary's testimony remains unchanged. So do the additional testimonies of the uncharged victims. There's still a propensity argument available should this case ultimately have proceeded without the background, the bookmarks, or without the prosecutorial error allegations. In addition to that, Jane's allegations are corroborated. They're corroborated by a box of sex toys found in Cunningham's closet and their location, as well as the panty collection, in addition to the forensic interviews that were introduced at trial. So ultimately, the state asked this court to affirm in accordance with the Court of Appeals. Pending further questions, I'll stand on the written brief.
You discussed the relevance argument you've provided for us. What about undue prejudice? But what's the state's position there in terms of responding to any argument that even if it just barely passed that threshold, the prejudicial force of those bookmarks might have warranted exclusion?
Yes, Your Honor. First and foremost, I'll point to the corroborative portion of the relevance, right? Jane's, the forensic interview discussed videos that Cunningham showed her. The titles that she discussed, not a verbatim quote for sure, but how else would Jane have known of these titles? First and foremost. Secondarily, the importance of the charge. The state had to prove beyond a reasonable doubt Cunningham's sexual intent for, I think it was 4 of the charges. And so because of the requirement that the state prove those charges beyond a reasonable doubt, that cuts against the undue prejudice argument, and a finding that it would be unduly prejudicial that the bookmarks come into evidence. Seeing no further questions, I'll stand on the brief. Thank you.
Thank you.
May it please the court, 2 things. First, the state used the word perfectly proper when it was discussing the first prosecutorial error I alleged, which was the vouching for credibility of the victim in this case. Due to the context, I suppose, that the statement, "we believe her," was made in, that's never going to be perfectly proper. I've heard this court repeatedly refer to that particular prosecutorial error as touching the third rail. You touch it, you die. It is an egregious error to commit. It is reversible error. The second thing I wanted to point out is a little bothered by the fact that the state referenced the bookmarks in this case, again, with ambiguously at least, because issue 2 of my petition for review asserts that the Court of Appeals materially misstated that fact, that this was a Celebrite extraction report that Agent Celeste bookmarked, and that the Court of Appeals materially misinterpreted the record when it said that my client bookmarked these videos to his search bars of his Internet Explorers. And that's not simply a situation where the state can just say, well, maybe the record's ambiguous, even though I don't think it is. The Attorney General's office compiled and produced this exhibit. Pursuant to Brady v. Maryland, we impart actual knowledge. They know or should know whether or not that report says my client put these onto his search bar as bookmarks. I'm a little bothered that they have not notified the court one way or the other, because in State v. Sheets, this court said we have a duty to correct material misstatements of facts in the Court of Appeals opinions. And to the extent they are suggesting that Agent Hackmeister may have misspoke during his testimony, well, that would be perjured testimony, and they also have a duty to correct that. So I'm bothered by the fact that they have not addressed that one way or the other, because I don't think they can take the position they took in their response to my petition for review. Finally, it's, again, goes back to what the state's argument is, the same thing that the Court of Appeals did. If they're continuing to claim that if sexual intent or arousal is at issue as an element, that this can be admitted, which again, if that were the case, Smith and Boland would have come out differently, because that element is at issue in both of those cases. I am happy to stand for any final questions, but would otherwise ask this court to reverse the decision of the court.
I have a couple of questions.
Absolutely.
It seems to me, I mean, we've had a lot of talk about relevance. Relevance is the core legal question here of the pornography to the alleged crimes. And I wanted to ask dig in a little bit to the analogy that you drew at the very beginning of your arguments about horror films.
Yeah.
I'm curious how committed you are to that analogy. If we had a gruesome torture, murder allegation, and the defendant was found to have possessed some of the darkest snuff films that exist on the corners of the internet, would you make the same argument?
Snuff films, maybe not, because at that point we were talking about material that I'm assuming is illegal to possess. It is certainly illegal to film if we're talking, because
Well, it's all acted. It's all.
Oh, and acting. No, then yeah, I would absolutely commit to that.
Even if it looks, I mean, so, okay, how about this hypothetical? I know, thank goodness I've not ever witnessed, but I know that on, again, the dark corners of the internet, there's a cottage industry of videos of people torturing animals.
Mhm.
Maybe that's all fake. Maybe it's AI generated. I don't know.
Mhm.
Is that not relevant to a charge of cruelty to animals?
It could be. I think the line that I'm going to stand on, and I think that makes sense, is whenever the conduct becomes illegal, we're in a different realm, because we're not talking about art once a crime is being committed. So to the extent that, for instance,
Why isn't, I mean, I won't repeat the titles, but you're arguing that these titles are art.
yes,
And why wouldn't the same exact argument be applicable to an quote unquote artistic depiction of cruelty to animals? Or a snuff film?
again, fine. I suppose it just doesn't logically, again, complete the thought then. Do you think I have a propensity to commit violence because?
Well, that's why I wanted to press into, I mean, you analogized to broadly available
doesn't offend the broad sensibilities of society, R-rated movies that are shown in every theater in the country. And I wanted to really see how committed you were to that. Does that analogy continue into the more edgy, more difficult to find? I'm searching for adjectives. Portrayals that really are not part of the mainstream, are not accepted in the mainstream.
I don't think internet pornography is that difficult to find. I think that we have a tendency, again, because
So again, you're committing to the idea that a fictionalized snuff film is not relevant to a torture murder case, and a fictionalized torturing animals is not relevant to a cruelty to animals case.
I would be very surprised to see the state ever seek to admit a violent movie in a homicide or aggravated battery case. I don't think that they would do that. I think the reason they do it here is because same reason you won't repeat the titles. They're hyper prejudicial. The state knows exactly how a small town jury is going to react when they hear these titles. They are going to be blinded to any other evidence that was presented. They are going to think the person is a sexual deviant who deserves punishment. That's why the state does this. They did it in Sheets. That same prosecutor, after having success on that very point, did it again in Cunningham. That's the whole purpose of it. And with that, I would ask this court to reverse the decision of the Court of Appeals, reverse my client's convictions, and remand for a new trial without the admission of this evidence. Thank you.
Thank you, counsel. Thank you to both of you for your arguments. The court will take this matter under advisement.